topic is everything that you wanted to ask about legal and HR, but were afraid to ask. But the topic is a bit ironic because if you look at our forefathers, contracts and business actually didn't go hand in hand. Business to them was word of mouth and trust. And today there is a dilemma between contracts and the word of mouth.
In a layman's term, basically it means that if the party did not contemplate the happening of an event which is beyond their control, then the party can delay the performance of the contract or put the contract to an end. So that is force majeure. As far as essentially, it is a concept where the parties have not contemplated at all in their contract what would come after signing the contract. So for example, if the happening of an event makes it impossible for them to perform the contract, that's where you are able to put the contract to an end. So you do not have to have it in a contract, but for force majeure, you must spell it out in the contract. If you don't have it in a contract, then you cannot use that clause to your benefit. In your contract, which is your tenancy agreement, most of the time, you have a force majeure contract, it will be, or term, it will be more in favor of the landlord, assuming you do not have such a clause. Contractually, you are liable to pay your monthly rental. When our Prime Minister made an announcement encouraging landlords to renegotiate to allow tenants at least 30% reduction of the rental for at least for 3 months. If the landlord were to give such a reduction, then you can apply, or rather you can get tax rebate. It depends really what the landlord and tenant are able to negotiate.
You'll have to send a demand letter and ask for the full rental because you're giving him a 50% discount. So if the tenant is not going to accept that, then he's at the loss. You take what is best, cut your losses and move forward. Otherwise, if you take this matter to court, the landlord is entitled to the full rental.
Do you have a contract? If you do not have a force majeure clause, then honestly, the only thing that one party should do, and this applies to all businessmen, they should pick up the phone, call up the party, talk to them and says, look, I'm willing to defer and supply you in stages. You take.
They call it the pain and gain strategy. Some of them say that only senior leadership should feel the pain and the gain should be given to the bottom part. So another group of our clients who are in the retail industry, instead of working 5 days a week, they made it 3 days a week, renegotiated some of the benefits, and where possible, got everyone to take annual leave. We are what we are because of our employees, and our clients pay us to provide service to them thanks to our employees.
Now, before the 23rd of April, we can issue a winding up of a company just based on outstanding payment of $10,000 and by giving a 21 days notice. But on the 23rd of April, temporary changes were made to the Companies Act, whereby the threshold to sue will now be increased from 10,000 to 50,000. But this is the best part. The notice from 21 days has now been given to 6 months. This has given a lot of breathing space to the companies.
First thing that the borrower or the customer should do is approach the bank, request them to restructure the loan that they have with the bank. As we know, with the moratorium, it expires on the 30th of September 2020. So in October, you have to commence your repayment as far as your loans are concerned. And of course, whatever the deferred interest is concerned, you have to negotiate with the bankers to allow you staggered payment. Most of the bank will be quite willing to consider this if there is a potential that the customer is able to revive their business. So where they can, where it is to their benefit as well as to the customer's benefit, they will consider the customer's plight. So essentially, you have a sale and purchase agreement. You already have time of essence. Let's say it's 3 months plus 1 month. The first thing the lawyer acting for the seller or the buyer should do is to communicate with the other side and agree among themselves that time has to be suspended while the MCO was still in effect. And whatever extension of the time is, you consider that time has been suspended and you get an additional, say, 1.5 months to conclude your contract.
the right of making the judgment is on the employer. And if the financials of the organization allows them, they should probably continue giving them the bonus, but probably negotiate installments in paying that. But if you were to go to on contractual rights, bonus is a not a right of an employee, it's a right of an employer. First of all, it doesn't affect the wage subsidy because wage subsidy is linked to protection of employment. Unless they are retrenched, then they are defaulting the wage subsidy. Other part of the employee not coming to work, there are two components to it. If you look at the softer component, I think every employer should go back and speak to those employees who can't come to work, why they can't come to work. Some may have just recovered from a COVID situation. There may be various conditions which you may not also want the employee to come to work, right? So addressing the softer issue, it's important first. Now, for reasons of taking advantage of not coming to work, let's say someone wants to play hard and say that I don't feel safe coming to work. The government has lifted the MCO or made the MCO conditional, right? So then it is a default from the employee not coming to work, which means the person has exercised the clause of no show at work. What you can apply is probably an unpaid leave. If your contract allows you for termination, if the person doesn't, example, come to work for 48 hours, if there are no valid reasons given. I think it's a time of shared responsibility between both employer and employee, right? So what some companies or some of my clients are doing is getting parents to work on staggered hours. Say, example, mother works in the morning and father works in the afternoon. So there's someone to take care of the kids, right? In situations where you can't have that at all, where both parents have to go to work, but either one has to stay back home also because of no choice, then either the person is taking the annual leave or unpaid leave. How companies had planned for crises and contingencies. Those companies who had planned significantly in crisis management, contingency planning, and many other secure technology in platform. So the readiness brings a lot more value to the business during this situation.
The biggest lesson all of us have learned that the fiscal position, we do not plan in terms of having enough or sufficient funds to maintain the operation of an organization.
To doing hearings on Skype, and I was not doing it before this. So I think I learned a lot about how to be, to use the technology better at home.
With that, I'd like to thank three esteemed panelists, Jai Jinendra, Jai Sri Krishna, Jai Swaminarayan. Good night.